Hi, I'm Brian Hanning with Hanning Law Limited. I'm an attorney who works with creative companies and individuals about uh, putting together contracts, companies, and dealing with copyright in all kinds of situations. And so I'm here to talk to you today about copyright for your business. And we'll start with the disclaimer that this is educational information that is generally appropriate for everyone, but may not apply to your situation or may apply in a different way for your situation. So if you have specific questions, please feel free to reach out. I want to start with a definition of copyright. And if you talk to me, I really love starting with definitions. That's just building from the basics is what makes the most sense for people, because at the beginning of the day, it's all about getting off on the right foot. Copyright is the term we use for an area of law covering artistic work. And it's based on that idea that you have the right to copy. It's in the name, right? And it comes out of printing and that kind of stuff, but it covers so much more. Specifically, copyright covers any work that is within this idea of an original work of authorship that can be perceived now or in the future by a third party in any means. And it's fixed so that that audience can see that work again and again. Because of that, what we're talking about are these things that we have finished. Your draft probably could have some copyright protection in it, but it's a draft. It's incomplete. It is the thing that you publish, the thing that you've put your heart, soul, and energy into, and you've created a YouTube video covering whatever, and you put it out there. It's published, it's fixed, it's done. That's what gets copyright protection. You write a script, you've reviewed it 17 times, it's finally perfect, and you're ready for somebody else to have it. You're forwarding it to the developer, or the podcaster, whoever, and they're using it. It's fixed, it's finished, it's done. Copyright protects what's done, and while there is no sweat of the brow aspect to it, there is this key that it is something that you have made that is artistic. It's not an idea, it's not scientific expression, it's not the building blocks of how you get there. It is your work as a whole. So what kind of things can be protected under copyright? Well, it's anything artistic. A presentation, a nonfiction book, a fiction book, a play, a choreographed dance, specifically the choreographic instructions, fine art, pop art, comic books, music, classical, jazz, rap, whatever. Anything that can be fixed so that somebody else can perceive it exactly as you created it. I highly encourage going to the copyright.gov website. They have some great graphics and really interesting elements to show what is and what isn't registrable. You can click through and go to their big old lists. I have spent many an afternoon perusing because it's fun. It is about finishing the work and making the work reproducible, making it something that can be copied. So, keep that in mind. when you've got the work done, when it's published, when somebody can see it, what happens? Well, the first thing is you're granted certain rights. This is guaranteed under copyright law. It is completely without limit. Okay? So it doesn't matter if you filmed a TikTok video or written a 500-page novel. As soon as it's published, you get these rights. You don't have to register. You don't have to take any further steps. Those rights are the right to copy it or to reproduce, i.e., I want you, and you to look under your chairs and get a copy. You have that right. You have the right to distribute, i.e., I'm going to put up a little stand out in front of my apartment, in front of my house, and I'm going to sell books or paintings or whatever out there. I'm going to go to Fort Collins Comic Con or one of these other conventions and sell what I'm putting together at a booth. These prints, these tools, devices, pins, etc. You have the right to create derivatives. That is, I've made this image. It's a really cool picture, and I'm going to make it a pen, a book cover, a print, a whatever. I'm translating it into different mediums. I can also translate into other languages. I can also create sequels or prequels, whatever I want to do with it. It is all based on that original work. I have the right to publicly perform it. That means I can read my poem at a poetry jam. I can put my video on whatever platform and somebody can see it in public. You can publicly display things. Same concept. I've got a book. I don't want to read it, but I want people to know it. I'm going to put it out so that people can see it. Marketing, in essence. Performance and display is marketing. You can market your stuff. Right to digitally transmit. Again, this is primarily going to be sound recording, so podcasts, music, songs, etc. You have the right to stream it through whatever third-party platform that is digital. You can also put it on the radio. It's those kinds of things. All of these tools, all of these rights are to take the work that you've created and to control its sale. You have the right to market. You have the right to sell it. You have the right to provide the right to sell it to a third party, publisher, a platform, etc. It is the idea that when you create the work, you have the right to exploit that work, that right to merchandise it, the right to market, the right to sell it. And these are all of those tools for that. And for a lot of people, that's where copyright ends. I don't want to be too much on anything, but the idea is that when you create it, you can sell it, and then you just don't worry about it. This is a lot of what happens with content-based businesses. You go to your favorite YouTube channel, and they're putting the video out every single week. Do they necessarily care that video 4 of 500 has been stolen? No, because their platform and their purpose is to constantly generate new content. And that's the same with many podcasts. It doesn't necessarily matter what happens to podcast 12. They're trying to do a series of 1200. The reputation, the sourcing, the value is in the additional content being put forward. And so their biggest concerns are about the relationships and about the pieces in place that lead to the publication and sale. Once it's out for market and consumption, it's directed to a Kickstarter, a Patreon, some third-party platform that then funnels a consistent stream into the creator. At that point, they've exploited the copyright to the extent and amount that they desire. Other companies or other business models are not on a volume basis, meaning that their focus is about exploiting one work as far and as much as they can. Think about it like an author or a movie studio or a video game studio, where it takes 2-3 years or more to go from idea and conceptualization through the entire process before they are in a place that they can publish it. They want to recuperate the cost of those past 3 years, or however long it took, and they want to fund their next project, which means that it's more important to make sure that that work is under their dominion and control for as long as possible. So how do we do that? Well, we look at some of these other tools. One of them is the tool to make sure that you're the only one who's doing the distribution online. That's your Digital Millennium Copyright Act. One of them is the new Small Claims for Copyright, the Copyright Claims Board now accepting claims and matters, which is supposed to be a quicker and more efficient way of addressing claims. But at the end of the day, it's about registration and getting the public acknowledgement that you own it for now until the end of that registration period. So we'll get to registration in a minute. I want to talk about the DMCA, the Digital Millennium Copyright Act, and the Copyright Claims Board first. With the Digital Millennium Copyright Act, you don't necessarily have to have a registration. You should have one if you're going to use it, but you don't have to. And the reason you don't have to is the process is this. I see that my video talking about the rise and fall of the Roman Empire has been stolen by this other company or this other entity, and it's on YouTube. I take a notice and I send it to YouTube, and that notice says, in essence, I created this video, it is mine, it's on my channel, you can see it here, but it's also over there, and they don't have the right to do it. I want you to take it down. Now we got to do some contact information and some other steps, but that's the idea of it. And a lot of times that platform holder will just comply. There won't be any pushback, any challenge to it. It will just happen. Because the trade-off for the platform is the platform can't get sued if they do the takedown and comply with the process. Now, the reason you would want a registration is if you get pushback or if the person using your video comes back with a valid defense, and you then have to take it to court to prove that it should be taken down. But the idea with the DMCA is that with the internet, there is such an availability of infringement that it is faster, smarter, and wiser to make sure that we can deal with these expediently rather than expensively. And so it's going to be very hard in many circumstances for this not to be complied with. So it becomes a very powerful, very useful tool. Yes, it is overused in times. Yes, it encompasses and ends up taking down valid uses of the copyright. Yes, it is outside of jurisdictional proceedings. It's done by the platform. and for the most part, all of the recompense is through the platform, which isn't necessarily good, right, or appropriate. But for you as a content creator and as somebody creating a copyrighted work, it may be extraordinarily powerful, useful, and something that you want and will want to use. The Copyright Claims Board is where that registration starts to become not just necessary but required. See, under copyright law, you have to have a copyright to sue somebody. And in this sentence, copyright means a registration through copyright.gov, which is the Library of Congress. The Copyright Claims Board, which has just started accepting claims, allows for you to file your registration at the same time as making the claim. There will be a delay before the claim proceeds, but you can do it contemporaneously. If you're going through district court or through the court system, that registration needs to be complete before the lawsuit. The reason it exists is because district court is expensive. It takes a long time, and it's not necessarily through and to a judge who's familiar with copyright, which can be both good, bad, and otherwise. We definitely have circuits of federal courts, specifically the Second Circuit based out of New York and the Ninth Circuit based out of California, that are leaders in copyright because of the publishing and movie industry respectively. However, that doesn't necessarily mean you're going to get a judge that knows it inside and out. With the Copyright Claims Board, you have more of a guarantee because you're going into a tribunal hired by the Copyright Office of copyright experts who will deal with your copyright claim. It's intended to be faster, with better experts and less expensive. We will find out how true those claims are as it gets going, but at least initially that's the purpose and intent. One of the biggest problems that I'm seeing that could come up with it is that the Copyright Claims Board is a voluntary proceeding. So if you end up suing somebody and they go, we don't want it in this venue, we want it in court, it will go to court. We'll see about it. But what the Copyright Claims Board covers is 3 jurisdictional elements or types of claims. You have claims of infringement, i.e., I'm a photographer, I take a picture, I see somebody using that picture, and I place a claim against them. That can be through the CCB. The second is a claim of non-infringement, i.e., I am about to publish a book. The book includes something we could look at and say, hey, we're worried that such and such company could see this as infringement. Copyright Claims Board, tell them they can't sue me because it's not infringement. And third, hey, this DMCA action either is appropriate and should be pushed through, tell them it should be pushed through, or hey, and it's a false claim, it should be kicked out. There is a decent amount of fraud with DMCA, so it's a valid reason to be pushing. The CCB's claim limit is $30,000, so it is substantially less than the statutory damages in district court. You have to pick the way that you think is best to pursue your claim. We're talking about lawsuits, right? Hopefully it's a quick one and it gets settled and resolved and it's not a big, long deal. But we need that registration. It is the proof of the hammer of lawsuit. The question is, what does registration do for you? How long does it last? And then what does registration cover? What does it do? Well, we talked about it. It's a lawsuit piece. There are a couple of other elements with that. Part of it is it's intended to help the Library of Congress grow ever more because you have to do deposit copies, but it's for a long period of time. For a company that has hired somebody to do it, it's 100 years. For you, it's the life of the author plus 75, 70, 70, 75. I always forget and think I need to look it up, but it's a ridiculously long time. That's the point. The point is that you as a writer, painter, whatever, and you should have the right to get all of that for the entire period. Hopefully you get, but it's recognition that it can take a long time to fully see the value of your copyright. But what does a registration cover? Well, it covers the work holistically. I've painted a mural. It covers the mural. It doesn't cover the stars in the mural, because anybody can paint a star, but it covers the mural and the scene and all of the pieces of it collectively. The same thing with a book. It covers the book holistically. It doesn't cover your sentence, because anybody can put together a sentence, but it covers all of the sentences in the particular arrangement. Maybe it might cover a sentence specifically if it's a big important sentence, but generally it's the broad scope of things. It's not the particular musical element. It is the sound and the impression of the music. It's not the idea, it's the expression. And of course, there are and will always be situations where specific elements are protected. If you think about the Vanilla Ice Queen piece, where it was a question of, was it changed enough by a single note? When we get into court, it's all about the facts in the situation. Generally speaking, we are talking about a whole. Does the song as a whole sound close enough that it causes problems? Different things like music, we're going to be looking at smaller elements, because smaller elements can be the basis of a vibe, of a situation, of a sound, where we would look at a bigger thing with, say, a novel, because if we break it down to small, it's just words, and everybody has access to those words. So there's a balance of where we are testing these things and how we're testing them. One of the things to consider is whether or not it makes sense to register one or more registrations and works. And what I mean by that is, we already talked about situations where it may never make sense to have a registration. But if you have one work and that work is important, you may just need to register that work. However, for complicated works, we may be looking at multiple elements of registrations, plural. Why? Because if we're doing a film, what do we need? What do we want to protect? Well, we want to protect the film, and we want to protect the parts of the film. So what does that include? Well, that includes this movie itself. We've got the whole. But we also have a soundtrack, and not all of the music in the soundtrack is in the film, and we also want to sell the soundtrack separately. Maybe we need to register the soundtrack. Okay, but we spent a lot of time and effort on this, and we wrote a really good script. We don't want somebody to take the script and write a similar story. Well, maybe we should register the copyright of the script. Great. We now have at least 3 copyright registrations going for a work, but it's for different works and for different purposes. This can make sense for some work, some situations. It's not a guarantee or a thing to say that every time you create a copyright, you need to look for as many as possible. No. It is simply to say, when you create a work, we have to look at and think about what is the key piece about it. Is the key piece the recognition and the volume? Well, in that case, what's one registration versus none? Or is it, we've got this one work and it's very solid and it's good and that's what we need? Well, maybe we just need that copyright. But what if we've done this really big, complex, pretty work? Do we want to have a separate thing about the art versus the whole versus the script? Maybe. So we really want to look at the situation. We want to look at what your goals with that work are. And then we want to proceed appropriately. So now we have a copyright. We've got the registration, if appropriate. What next? Well, the answer is you've created a work. Now, how do you sell it? Or you want to create a work, but it's beyond the scope or ability of one person. How do you create it? The answer is going to be it's about relationships, and we write those relationships down in a contract, hopefully. Because what contracts do is, one, they set up expectations and manage relationships, while at the same time, two, being the writing under which copyright is transferred. Meaning, if I'm working with my friend and we're going to paint this mural, we both need to give up our copyright to a third party to display the mural. Because now it's on the side of a building. They've bought the right to publicly display it because it's their mural on the wall. So we're selling that to them. And that should be by copyright. Both how many edits, how much time and work and payment we're getting for putting this mural in place, but it also transfers to them certain of the copyrights to allow them to display it and to hold it, and if they sell the building, to sell the mural with it. Contracts are relationships. They are how we publish. We go through a publisher. What does that contract look like? What does it contain within it? What are the elements there? Look, we want these agreements in place, and we want them well written because handshake agreements are hard to prove. It's not to say you can't sign on somebody to hold your ladder and to bring you paint, and that you don't really need a contract for that. You probably don't. But if they come and say, hey, I was an integral part of creating this copyright, I deserve royalties from this copyright. How do we prove that they don't? We enter evidence, we talk things through, we negotiate things. Having that contract, having that piece of paper that says it, is just going to be easier and faster, and the thing we want to do. And this is my lawyer paranoia coming in, right? Because for you, will you ever have that problem? I hope you don't. I hope your entire career is smooth sailing and everything goes well. I work with enough clients that I see things go wrong every day. And I don't want that to happen for my clients. And we try to put things in place so that if and when things go wrong, we have contracts that are tools to help us get out of these situations. We want to make sure we know who owns the copyright. We want to make sure we know when we're transferring part or all of that copyright, what are the terms and how do we get it back? It is a complicated and simple situation. Having that contract, putting these things in place, dealing in these areas of contracts can help us deal with the situations. Copyright law is about protecting the work. But using the work and using copyright is about balancing, protecting us as people, protecting us as our business, and getting the work out into the world in order for fans to develop, for fans to exist, to buy our work, to make fan fiction and fan creations, and to go and be amazing, and to get what success that we define. And because of that, we want to put the things in place intentionally and with that plan to start with, so that we can reach our success with as little trouble as possible. I wish you the greatest luck in developing your copyright and in pursuing your dreams of this creative business. And if you have any questions, please either reach out through the Larimer Small Business Development Center or through my contact information, which is at the beginning of this presentation.